Jennifer Sue, briefing on California Assembly Bill 610. Briefing on California Assembly Bill 610, Jennifer Sue.
Thank you. Good evening. As a child support caseworker, I remember working a case with this guy named Tony, and he first contacted me after he was released from prison. He had served an 11-year sentence. And he was excited because he had found a job at a call center earning $17,000 a year, and he wanted to start to do the right thing in his life, so he contacted me to tell me where to send the wage garnishment. Well, when Tony was in prison, his children had grown up and emancipated, and now he just owed past due support. He owed over $100,000 with interest and everything, all totaled. Why did he owe so much? Well, when he went to prison, he never petitioned the court to modify his child support order. So until his children turned 18, he was still charged child support every single month. Tonight, I'm going to brief you on new legislation, Assembly Bill 610, that was signed by Governor Jerry Brown in October 2015. And after the briefing, there'll be a question and answer period. This legislation is designed to help people like Tony. But before I get into what you need to know as caseworkers about the legislation, I'm just going to provide you some information from the California Urban Institute, some facts on incarcerated parents in the child support program. So that California Urban Institute did some research and found that that specific population in the child support program, people who went to jail, 50% of them 2 years before going to jail had no reportable income. And the other 50%, their median income was $3,000 annually. Now, before going to jail, the median child support arrearage, the median child support debt was $15,000. So this particular population wasn't doing very well at all before going to prison in meeting their child support obligations, let alone they were not able to pay once they went to prison. This study also found that once people were released from prison, if they owed a large child support debt, they tended to avoid working in the formal economy because they felt it was just too much to have their wages garnished at sometimes 50% of their income. So now I'm going to brief you as caseworkers on 4 facts that you need to know about Assembly Bill 610 in order to process cases correctly where you have a parent who's incarcerated. The first fact that you need to know is that AB 610 suspends someone's child support obligation by operation of law. They don't need to go to court anymore to modify their child support. They just need to serve a 90-day sentence or longer. Now, there are some exceptions. If somebody's in jail for failure to pay child support, the obligation doesn't suspend. If somebody is in jail because of domestic violence towards the person that they owe the support, their support does not suspend. And then finally, if they have means, if they have a large stash of drug money or something that's provable, then their child support will not suspend. So the second thing that you need to know is that it doesn't suspend automatically. There's a required notice. So as a caseworker, you'll need to send out a notice to both parties, the person who owes and the person who would receive support, and give them 30 days to object to changing their obligation administratively. So if nobody objects within 30 days, the child support caseworker can go ahead and stop the charges. If there is an objection, it's the department's responsibility to file a notice of motion to modify support on behalf of these parties rather than just letting the obligation run. And then the third thing that you need to know, once somebody is released from jail, 30 days after release, that prior order goes back into effect, again, by operation of law. No need to go back to court. Now the final thing you need to know is that this is a pilot program. It is going to sunset January 1st of 2020, and the legislation provides for the Department of Child Support Services and the Judicial Council to meet on or before January 1st of 2019 to analyze the efficacy of this pilot program and decide whether or not to continue it. So in closing, it's really important if you're working cases where payments aren't coming in or payments have stopped, that we utilize our locate resources to determine whether or not somebody's incarcerated so that we can appropriately apply the relief in Assembly Bill 610. So now I'm going to open up the forum to any questions or comments. Does anybody have any questions about Assembly Bill 610 and how to implement it on our cases?
So the theory behind this is that if they don't come out of jail overwhelmed in debt, they'll try to become more involved in society and get a regular job.
Yes, and the law allows for a modification of a support order when there's a change in circumstance. It's just that this population in particular tends not to ask for that. They're in overwhelming circumstances, and historically they haven't, although they do have access to legal help in prison, they haven't availed themselves of that. So they're a population maybe that's less likely to be proactive and do what they need to do to go back to court and change their order.
Does the law has a retrospective effect to relieve people like the one you?
Yeah, excellent question. It doesn't. It goes into effect as of the date of legislation, October 2015. But say the child support program doesn't, somebody goes into jail October 2015, the child support program doesn't find that out until this month, June 2016. The program can go back and suspend the support back to October 2015, but it doesn't help our friend Tony.
What will happen when AB 610 expires in 2020?
Well, if it's not renewed, then this will just be an amnesty for a period of time. But after analysis by Department of Child Support Services and Judicial Council, if it does work out well, it will be extended. Suzanne?
Okay, does the legislation impact old cases and periods of incarceration?
It does not. It just takes effect as of the date of the legislation.
Does the legislation impact old cases and periods of incarceration?
It does not. Only back to the date of legislation, October 2015.
Might it not be a little challenging if people who are incarcerated are getting some kind of official legal notice that they may not understand exactly what they're supposed to do with that or how to respond?
Yes, it could be challenging. Every California state prison does have a litigation officer, so if they're able to recognize what this is and avail themselves of that assistance. But basically, if they don't read it, they don't do anything, we can help them.
How do you find out if someone's been incarcerated, and does it also include people that are involuntarily committed?
Yes, it includes people who are involuntarily committed. We, because of HIPAA laws, we don't generally find that out through our locate resources. So that we would depend on reporting by one of the parties, the person who owes or the person who receives the support. But otherwise, we have an interface with the California Department of Corrections to find out that information, and there's also a lot of public access information from various other states' prisons and the Bureau of Prisons, the federal prisons. So that's it. I will go ahead and conclude my speech. If you have any more questions about AB 610, please email me or see me afterwards. Thank you.
Okay, you know, I'll take